Hi there, this is Erica Merrill. I am the founder of Perfect Legal Video. I am very excited to have Attorney Desiree Claudio today with us, and we are going to be talking about child support. And Desiree is an attorney out of New York City. She's a family attorney. She's in court all the time handling these issues. And so really excited to talk to you today about all of the facts surrounding child support. Thank you so much for joining us and welcome.
Oh, thank you, Erica. It's such a pleasure to be here.
I wanted to start off with, what is child support supposed to cover in general?
I want to, if I could, I want to start with just some quick preliminary answers about who would be entitled to child support and how someone comes in the door. One of the big questions I get when someone comes in asking about child support is, well, can I, if I can actually request child support? And the first thing I ask is, well, child support is based on the fact that the two parties have to be living separate and apart. Child support is based on the parties being physically separated. That doesn't mean you have to be divorced per se, or if you're not married and you have a child together, you can still request child support. You just have to be physically living apart. The second preliminary question I think I get is, well, when does child support start? Can I get child support from the date that the child was born? And that's something that comes up pretty often with my clients. And I tell them immediately, no, the child support begins from the date that you filed the petition. So, even if you and your spouse or your partner have been separated for, let's say, 2 years, and now you're coming to court, you won't be able to get that back 2 years worth of child support. It begins from the date that you filed the petition. Now, regarding what child support encompasses, yes.
Actually, just interrupt for a quick second. When you say the petition, you mean they file for divorce, or is it from when they filed specifically for temporary orders?
So New York is very different from a lot of the other states, right? So I also practiced in New Jersey, and it's fairly different in that in New York, there is two separate courts. There is the family law court, and then there's the Supreme Court that handles divorces. Whereas other states, for example, New Jersey has one court that handles divorces and any issues relating to children. And in New York, if you're married to the other partner and you're seeking a divorce, you would go to Supreme Court. And in the divorce, you can ask for these other issues, right? You bring up these other issues: child support, custody, equitable distribution of property. Whereas in family court, you can be divorced, you could be married or in a relationship without being married and still have a child together and have these issues. And so when we speak of child support in family court, it's a petition that's filed specifically for child support. If you're seeking a divorce in Supreme Court, then you can also ask that the court, encompassing the divorce itself, that you deal with child support there as well. So as it relates to child support specifically in the Supreme Court, it would be from the date that you file your complaint. If we're speaking of the family court child support, it's a petition from the date that it's filed. That's when the child support would begin.
Mm-hmm. Okay, so you were going over some of your preliminaries before we started, and whenever you're ready, the first question is, what is child support supposed to cover in general? Once you file it and you're living separately and you know that you're not the moneyed spouse or partner, that you're going to need some help, what does it typically cover?
So there's child support, which generally encompasses 17%. It's calculated based on 17% of what we would call the non-custodial parent of their gross annual income. So there's the custodial parent where the child resides, and then there's the non-custodial parent where the child does not reside, but perhaps that partner has visitation. So for the non-custodial parent, they are entitled to support for the child or the children. And normally for one child is 17%, for two children is 25%, for three children is 29%, and so on. And so child support itself would be a percentage of the gross annual income of the non-custodial parent. But there are also add-ons. And I find that my client, when they come in, they're either, whether they're on the non-custodial or custodial side, they don't fully understand that child support is child support based on the gross annual income. And then there are also statutory add-ons, one of which is very important that everyone is clear about, because I think there's a misconception about what it actually means. A statutory add-on is something that's in addition to child support, and one of them is work-related childcare. So if a custodial parent works and needs childcare from an after-school program, a childcare provider, or even a family member, the non-custodial parent is required to pay a percentage of that childcare expense.
So for summer camp, for example, or an after-school program.
Exactly. And it's important that the parties know, specifically the custodial parents, so that they're immediately prepared to provide the proof of that statutory add-on. And it has to be work-related, and it also has to be reasonable. So for example, if a custodial parent has a child in, let's say, an after-school program, and that after-school program runs from, let's say, after school 2:30 p.m. until 6 p.m., and that is required because the custodial parent has to work, then the non-custodial parent is required to pay a percentage of that amount. And it's important that everyone is clear about that, because you really should start thinking about obtaining the proof, making sure that you can prove that it's in fact work related. It has to be during the hours when you're working, in case that that information is somehow that fact is somehow disputed in court. You're able to provide that information, and that you know exactly how much you're spending on an hourly basis, on a weekly or monthly basis, so that it can be presented to the court, and it should be credible information.
And along that line, I don't know what other add-ons we're going to go over, but what do you say about if the kid is, and I've heard this, I was in court the other day and I heard somebody talking about how expensive their children's horseback, I guess they're like competing at a heavy level. So the horseback riding is not just a leisurely thing. It's like $50 a week. It's, hey, we rent the horse, we have to pay for the travel of the horse, we go to all these high-end competitions, and the girls have gotten very good. She's got 2 of them. They've been doing it for 10 years. And now with the divorce, it's like, maybe $10,000, $20,000 a year they're spending on this activity. What about activities? And it may not be that extreme. It might be just piano lessons, gymnastics, who's paying for the costume this year? I don't know. But that's a question that some of our viewers might have.
Yeah, and that's a good question. That would not be considered a statutory add-on because it's considered an extracurricular. But when those activities have come to a level where the child has done them for several years, that it's become status quo, as we would call it, something that the child has been doing even during the relationship, and if the party can prove that that the partner had been paying for a percentage of it all along throughout the relationship, and now has decided, I no longer want to pay for it, then it's at the discretion of the court. For example, in family court, there is a subfactor F under the Child Support Standards Act that will allow for a support magistrate to either order for this extracurricular to be paid, to continue to be paid for under a discretionary subfactor, or they would go over the cap, which is something else that comes up fairly often. There's a cap in New York of $184,000, so that if the party's parental combined income goes above the cap, then the court can, within their discretion, decide if the party does not no longer wants to pay this, but this is an expense that should be paid for because of status quo, then we would go over the cap to ensure that the support will take care of that particular amount. For the most part, however, it's something that the parties either consent to, or the court will use its discretion with those two areas.
I see. Now, when we're talking about this, I know for some people that have to pay the support, they're looking at, depending on how old the child is when they separate, a lot of years of paying this support. And so I know in New York, it's a little different than other states, just like everything. We're going to say that a lot. In New York, it's a little different. How old is a child when child support stops?
So in New York, the age of emancipation, which is the age where child support should end because the non-custodial parent no longer has the obligation, it's 21. And there are some exceptions to that, because depending on what the parties consent to. Now many of the states are starting to implement the clauses, but again, they have to be on consent, where the child will receive child support until they're 22 if they are attending at least 4 years of college. So if the child is matriculating full-time student in college, the child support will extend for 1 more year in New York. But the law on the books specifically states 21 in New York. And there are some exceptions. If the child is working full-time, if the child gets married, if the child over the age of 18, custody no longer becomes an issue. So after 18, if the child is no longer living at home, if the child is in the military, if the child is working full-time, if the child is married, there are some factors in which emancipation can trigger. But on the books, it's 21.
Okay. Now, once you have everything settled and you're looking at the add-ons and the cap, what's going to be paid over the cap, and the extra child support for childcare, and then just the regular child support, what happens if the parent refuses to pay?
So if the parent does not pay the child support, and whatever, specifically the order, then the custodial parent, the parent who's receiving the child support, has the right to file what's called a violation. And a violation is very serious, and I always tell my clients, if they are the non-custodial parent coming in with one of these petitions filed against them, it's extremely serious, because specifically in family court, and even in Supreme Court, it's the one area where you are facing jail time. So for a parent who is receiving the child support, the first step is to file a petition and to be very specific in their petition as to how much has not been paid. The law is very clear. The only burden the petitioner has is to show that this person has an order to pay and has not paid. So essentially, when you go to court, if your child support is being paid through the child support enforcement unit, or if it's being paid directly to Albany through the child support unit, you'll automatically get a certification of all the payments that were made and all the payments that were missed. That document with your petition specifically stating how much has not been paid, what's owed, is you've met your burden. It is now the respondent's or defendant's burden to show why he did not pay and whether or not it was willful. So you have a big hurdle to get over. You can't just say, "Oh, I lost my job and I wasn't able to pay," or I just didn't have it for a couple of months.
Yeah, no, absolutely. And a lot of people will say that, oh, that was supposed to be on my credit card automatically. I don't know what happened. Sorry, your lights got shut off. I mean, those are the kinds of things that happen, unfortunately. And they don't start with just sending someone to jail. There are steps involved. There's like several steps involved, things that they take away first. And can you just go over what those would be?
Sure. So if the payments are being made through child support enforcement has authority without utilizing the court system to remove the ability to utilize one's passport, to remove the ability to utilize one's driver's license, a professional license. If the person is a doctor or an accountant or has some kind of professional license, that will be suspended, and you will no longer have an ability to utilize that license. Those are done through the child support enforcement. The person receiving the child support does not even have to file to have that done. That's done automatically. And so for those clients that come in who are on the other end of it, where they were not able to travel because their passport was suspended and they're no longer able to utilize it, I immediately tell them to go to the Child Support Enforcement Unit. There's a location on Broadway in Manhattan, and work with the staff there in order to try to get a way to have either, for example, the driver's license. The Child Support Enforcement Unit will allow you to have a restricted license to be able to go into, come in from work, go to school if you're a student. So you can do those things, but that's all through child support enforcement. The court, however, has other authority, and that's where we talk about money judgments and jail time.
I mean, hey, and typically if somebody gets to the point where they're thrown in jail, they're usually out the next day, right? Or even that day.
They can be. It depends. The court can order up to 6 months in jail. I've had situations where the non-custodial parent was sentenced to 3 months in jail with an undertaking, which is essentially bail of close to $10,000, and he was not able to come up with the money. So until he stayed there for 3 months because no one was able to satisfy the undertaking.
Really? So usually though, people are like, oh my God, they're like normal people. They're not criminals, and they didn't think they'd ever be in jail, and it freaks them out, and they call everyone they know. One time I got a call from a boss that I hadn't seen in 7 years because he was put in jail for not paying child support. And I was just shocked.
Because you would never think someone like that would be, you didn't get that impression of him. Yeah, and that's very true. 95% of the litigants that I've had any kind of contact with in court will find a way. And I think sometimes depending on what the arrears are, depending on how much is owed, the judges have discretion as to how much the undertaking will be. And it's my job as an attorney, if I'm defending that litigant, to find ways to get the undertaking as low as possible. If I know for sure that this person is going to be recommended for jail, and our job now is to try to get the undertaking as low as possible and start contacting family members and friends to see if they can come down and pay the undertaking. So yeah, 95% of the litigants eventually come out within the same day or so because everyone kind of pulls together.
Yeah, all of a sudden they know where to find the money. Now, on the other side of the coin, I mean, usually people that have to pay the child support, not a lot of people like doing that, and they get angry if they think that the other parent is using the money on themselves and not the child. Which children are very expensive. There's so many hidden costs that, obviously you still have to take care of yourself as a parent, but but if that's the perception, like, are they allowed to use some of the money on themselves, or how can you even tell that that's happening?
That's a good question. I've had clients ask me if, we can put in the order or in the stipulation that they get an accounting every month of what is being spent on the child, and how, where the child support is going. So, and I totally understand. Um, but I will say this: after I used to clerk for a judge in New Jersey, and I did a lot of, as a clerk, which is essentially, I was an attorney. I worked for a judge, and I did a lot of memorandums of law, and I watched. I assisted the judge in all the things that he needed. And one of the things I did was I would assist the attorneys, both attorneys, in coming up with an agreement as to what child support would be. So I did a lot of calculation. And one of the things I learned from throughout the reading legislative history, determining where child support really came from, so that when clients came to me and had these questions, I would be able to explain it to them. And this is what I say every time. Child support is supposed to be for the expenses of the child based on the household expenses. So it's supposed to be a percentage of the water that's used for the child, right? So when the parent is paying the water bill, what percentage of that is being utilized by the child? The light, the gas, the rent, mortgage, all of those household expenses, food, clothing, all of these expenses that are included in the day-to-day caring for a child is what child support is for. So essentially, if you're paying your mortgage as the custodial parent, you're paying the mortgage, you're paying all the bills in the house, you're purchasing clothing when necessary for the child, you're purchasing household food. That's what child support is supposed to be for. In essence, it can be like a reimbursement, right? A reimbursement to the custodial parent for what's being paid, which includes the child's expenses. So if the custodial parent goes out and buys a car, or spends money on things that we would consider for themselves, it doesn't necessarily mean that the child support was included in that, and somehow that person should be penalized for it, or there should be some kind of accounting. So,
Exactly. And in that example, I would say that, a car, you need reliable transportation and gas to drive the kid around. I mean, I don't know how many parents that say, God, I feel like a personal taxi driver for my children because they've got to go here and there and they can't drive themselves. And you spend hours a day doing it. You also have to pay for insurance and leasing a car, buying a car, and gas and everything that goes into the maintenance.
yes. And usually once I explain that, everyone's, the litigants or the client will understand that's really why, that's where the percentage comes from.
I think that's a really good explanation. And I don't know if I've heard it explained exactly like that before. And I talk to a lot of family attorneys. I think that's a really great explanation. Now, I know that you handle a lot of different types of cases in family law. Um, how hard is a child support case if you're an attorney? Like, how do you, when you go into it, you're like, oh my God, this is going to be horrendous, or like, is it easy?
Actually, I'm glad you asked that, because that was one of the reasons that I chose child support as one of the subjects to discuss initially, because I find that when I speak to my colleagues, a lot of, even if they're very experienced family law attorneys, most don't like child support. I think part of it is because, there's your math, it's dealing with math and numbers, and perhaps there's 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 a lot of discretion depending on the Child Support Standards Act. You gotta know what documents to provide. It's sometimes you get clients who are not always happy, especially if you're on the respondent side. There's really no way of sort of buttering up what's about to happen. Child support is what it is, and after we do these calculations, if you're the non-custodial parent, you're more than likely going to have to pay child support. So it's difficult on the calculation side. It's difficult on the side of the client, because when you're representing the respondent, it's not always easy sort of giving them the news that, yes, you're going to have to pay child support. I find that because of my experience working for the judge, and because I've had to do several memorandums, and I did a lot of research on it prior to starting my practice, For me, I love it. It's easy for me. You know, it's not as challenging as, let's say, the other areas of law. I enjoy doing the calculations. I enjoy finding the little nuances, being able to argue those areas that maybe the client wasn't even aware that they were able to argue. I enjoy being able to bring in witnesses to, you know, when there are issues of fact, childcare expenses. Sometimes I bring in the babysitter, or when there's a dispute, I enjoy doing the litigation part of the child support. So it's actually one of those areas that I enjoy, and I find that it sort of gives me somewhat of a leg up on some of the other practitioners who say they really hate child support.
Hey, what do you bring in the babysitter? What do you ask the babysitter?
Well, because sometimes, you know, there'll be a dispute as to whether or not, if it's a family member, for example, and the other side, you know, the respondent will say, "Oh, that's just her mother, or that's a family member. She's not really paying them." And so we'll bring in receipts, we'll provide notarized letters, and there'll still be a dispute as to whether it's credible documents. And so we'll bring in, you know, and let them testify. Hey, look, I actually am caring for this child. My my daughter or my sister or whoever it is actually paying me every week to care for their child. And sometimes we have to actually bring them in as witnesses. So
Oh, wow. That's really interesting. I hadn't even thought of that.
yes.
Now, what happens if I'm paying my child support, but my ex is not letting me see the child, even though I have rights to see the child?
And I love this area because, again, it's one of those areas that not very many people know about. It's a challenging petition to make. It's a challenging request, because I think that it's somewhat of an untouched area. But if you are the non-custodial parent and you have an order of visitation, and the custodial parent is not complying with that visitation, and I mean it has to be egregious to the level of total alienation, where the custodial parent is just totally ignoring your visitation despite your request to have this visitation be complied with. And it happens pretty often, which is a whole nother area, which is the alienation part of my work. You can file a petition to suspend the visitation until suspend the child support until the visitation is complied with.
Wow. Suspend the child support until the visitation is complied with. So, sorry, you're not getting your money until I see my child.
Yes.
And that's great, because no child should be alienated as long as the child is not in danger. I find that to be, just such a huge problem. I know growing up, I had divorced parents at a young age, and they definitely use the kids against each other. Just a miserable for the kids. So, no matter how much you hate that other person, disagree with that other person, you should always slap a smile on your face, respect that person, at least in front of your child. I'm sure they can still sense some of it, but you have to make the greatest effort in making everything comfortable for your child. And it is just so heartbreaking when that doesn't happen. And you're right. I mean, that's a whole nother topic. Several things we talked about today, we could talk about for hours. So I'm really looking forward to our future interviews, because there's a lot to go over and a lot of great information that we can share with our audience.
Absolutely.
So those are the questions we have for today. And I feel like it's a really great overview of child support. And, we can break this down. And if people have questions, certainly you should definitely give Desiree a call, her office a call. They will have I want to say, are the first consultations free or phone calls free? Or
we do free 15-minute consultations by phone. If you want a more in-depth phone consultation, we do 30 minutes for $50. If you want to come into the office and meet me, it's $100 for the consultation.
Okay, great. I just wanted to make sure. So it looks like there's some tiers. I mean, I think honestly, if you, and this is a question I'll ask before we go, I don't think that you should do anything in court alone. But if you were considering that, what would be some of the reasons that you should use an attorney?
So I will say that my consultations will prepare you the best you can if for whatever reason you say, you know what, I really want to hire you for some, I'm not able to get the money together. I will give you as much advice and information and prepare you if you do need to do this pro se on your own. But I agree, you should not go on your own. And one of the major reasons is sometimes you may divulge information in court that may hurt your case. So when you have an attorney, you won't have to really say a word. I do all the talking for you. We can avoid you saying something that perhaps could eventually down the line hurt your case or put you in a position that's very difficult to get out of. The other thing is, just the stress of it. Sometimes the language in court that the magistrate might say is confusing to you. You're not sure how to answer something. I do all the talking again. The other thing I found that when people attempt to do it on their own, they don't know what to ask for, like the statutory add-ons and how do I ask for unreimbursed medical was something else that we didn't discuss. How do I know if I'm supposed, if I'm on the respondent side, where do I send my payments? If I'm on the petitioner side, how do I ensure that the payments are going through child support enforcement? There are so many different things that you won't know to ask for to make sure happens before you leave. And then we're in the situation where you get this order, you figure out, I didn't ask for certain things didn't go the way I wanted them to go. Now I have to file an appeal, or I have to file a motion for reconsideration. And now you're spending more time, more money, more effort than you would have the first time around had you just, made the effort to get yourself an attorney and go in court with one. And look, I understand that it's not always easy. Sometimes someone doesn't have the money, or maybe, they think that they can do this on their own. I would suggest that you call us, that you get a consultation. We'll work with you on the fees. And again, I'll give you as much advice as possible.
I mean, and I personally, 50% of the people now that get married are divorced at least. And I certainly know a lot of people, and there are people that I know that have done it on their own, and they absolutely get no support from the other parent. And, one of my friends had 2 girls and, really no support, and just accepted it and moved on with her whole life without any support. And, not having the other parent, be held responsible at all, and still giving him, visitation and that sort of thing. So it, just really, it can ruin your life if you don't get the right help, and you don't know what you don't know. So it's better to at least talk to someone for a little while and find out, what your options are. And these are often very, very complicated cases. So I'd like to encourage you, if you yourself or any of your friends or family, colleagues are going through a divorce, considering a divorce, even if they think that they're not going to file for another year, they should really start getting their facts together and start figuring out strategies so that they can go forward and, not to try to stick it to somebody, but so that, everyone can have a fair settlement to a marriage dissolving, which is really just like a business. So that's my advice. Definitely give Attorney Desiree Claudio's office a call. Their information is on this post, and if you're watching this video back after we've done the fancy editing, it's very obviously on the right-hand side of your screen. So please give her a call. And I want to thank you so much for joining us today. I know you're very, very busy. We heard your phone ringing off the hook while we're talking. So thank you so much for joining us today.
Thank you. I really appreciate you having me, Erica.
Absolutely. And we'll look forward to talking to you not later this week, but next week, possibly on Friday.
Sounds great.
All right. Thank you so much. We'll talk to you soon.